Good evening. Does that work? Good. Good evening. Thank you for coming tonight. Greatly appreciate your attendance. As you know, tonight we're going to be talking about estate planning. And I know a lot of times when people hear the word estate planning, they think of some wealthy individual or family that lives in a mansion and they've inherited millions of dollars. But that's not the case. In today's world, you don't have to be a Rockefeller or a Carnegie or a Gates, or a more modern name would probably be Kardashian. You don't have to be a Kardashian in order to take advantage of these financial vehicles. Our presenter tonight is Justin Leland. Justin is a financial advisor with MoneyWise Wealth Management. Justin is a registered representative. He's a fiduciary financial advisor, certified financial planner professional, accredited investment fiduciary, and co-host of the MoneyWise Guys radio show and podcast. In addition to assisting individuals with their financial planning and retirement, he also helps construct and manage the most strategic and optimal plans for both employers and employees. During tonight's workshop, Justin is going to focus on the need for careful action when it comes to managing your estate and conserving your assets. He'll cover estate planning fundamentals, challenges, distribution techniques, trust strategies, important documents, as well as current tax laws. So that's a lot to cover in the time that we're here, but I think you're going to find it extremely beneficial. And with that, I'm going to turn it over to Justin Leland from MoneyWise Wealth Management. Come on up, Justin.
Well, thank you, Mike. First off, that's a really long intro for me. First, I want to say thank you to the rest of our MoneyWise team. Obviously, thank you very much to Safe1 for helping to sponsor this and putting this together. But I'd also like to help and thank my team. Chelsea here helping check everybody in. TJ helping direct people in the traffic. Debbie's still out there, I think, directing traffic. And just so you know, everybody, my boss is here, Sami Abiyawi, managing director. He's my boss. So if you like today's presentation, my name's Justin Leland. If you don't like the presentation, my name is TJ. All right? So we're going to go ahead and get started. Hopefully this works. We were having issues with it before, but looks like we're still having issues. We click the next slide. There we go. And the next slide. That's the disclosure slide, says I'm not lying to you. All right, so what we're going to talk about today, first off, our commitment at MoneyWise is to provide sound financial advice. Period, end of story. That's our job here. When we do these types of seminars, we're here to provide the best financial advice and scenarios for you to be able to take home and use in your own life. We're here to help you identify the goals. You may not think about them, on a regular basis, but these types of meetings really do help you to kind of solidify those goals and put them into practice. So that's what we're doing here today. And then also help you strategically prepare for retirement. Again, many people in this room are already retired. So hopefully we're helping you with that process as well. But what we're going to be talking about today specifically is estate conservation, wills, trusts, powers of attorney, all of those types of things. So next slide. Who's ever heard of the Queen of Soul, Miss Aretha Franklin, right? R-E-S-P-E-C-T, right? Well, she passed away in, 2018, 2017, somewhere around there. And no formal will or estate plan. How much do you think that estate was worth when she passed away? No will, no estate plan. It did take years for that plan, for her estate to be adjudicated. Just recently, probably in the past 6 months or so, that has actually been finalized, and her heirs have been given the beneficiaries have received their part. We don't want to be like Aretha Franklin, right? The other one, Michael Jackson, a little bit longer ago that he passed. Now, he had a trust. He had an estate plan. What he didn't do is he didn't fund it. Just because you have a trust does not mean that it's in force. Okay, so we're going to talk about that as well, making sure that just because you have a will or a trust, you have to do certain things after that point to make sure that that will or trust is funded and that you know that those beneficiaries are going to get those assets. Next slide. Okay. So what is asset conservation and why is it so important? pretty simple when it comes down to it. These two real main things. We want to manage your assets during your lifetime, right? While you're alive, that's your estate. We want to manage those assets while you're living. But then when you pass, we want to make sure that we're giving those assets to the people that you want to give it to. Giving to the charities that you want to give to, if that's your thing. We want you to be able to dispense those assets where you want them to go. Okay? Next. We're going to go really quickly over some fundamentals, and then we're going to go through some more detailed strategies. Okay? Next slide. Okay. So the benefits of estate planning. First off, you get to select who received those assets. We will talk about specific strategies later, and I want to make this lively, so if you have any questions, by all means, you can ask during the presentation. But we want to make sure we're determining the value of that estate and distributing that estate. We want to choose the individuals to manage the estate. So once we pass, we want an executor or a successor trustee, whatever that case may be, to be able to handle those assets on your behalf after you have passed. Okay? We also want to help reduce the settlement costs, probate, those types of things. We want to make sure we're doing the best thing we can to avoid those costs. One of the big ones is choosing who's going to be the guardian for your minor children. Okay? I have 3 kids. 1 is an adult, 2 are still minors. If I got hit by a bus, who's raising my kids? Right? That's part of your estate plan. If you have children, you need an estate plan. Period. Okay? And to be able to provide the liquid capital for burial and those types of expenses. Okay, next slide. The challenges. Next. I had a clicker that actually worked. All right. So, first off, we want to make sure that if you're trying to put together a will or a trust or any kind of an estate plan, which we will get into the actual specifics here later of what those two things are, we want you to work with a qualified attorney. Okay? You can easily create a will by going to LegalZoom, but is it legal in the state of California? Has it been updated in the state of California? Talking to a licensed and basically a very good estate attorney, it might cost you a little bit up front, but it pays huge dividends down the road. Okay? Now, and you also want to hire an attorney that's willing to work with other professionals, whether it be your CPA, hopefully your financial advisor, because those individuals kind of know what's going on with your estate, know your assets, know kind of what makes you tick. So they can actually help to formulate what that trust is going to look like, what that will might look like. Okay? Ask for referrals. Your friends might give you a good referral. They might give you a bad one. I don't know about you, but most of my friends are like, don't go to this person. That's the referral. It's the negative, right? But you also can probably get some pretty good ones as well. And ask your financial professional. Okay, if you have a financial professional that you work with on a regular basis, the chances are that individual has worked with or knows a good number of attorneys that would fit with your personality, with your lifestyle, and your situation to give you the right attorney. We work with, and I can tell you right now on the top of my head, I have 5 or 6 estate attorneys that I work with, okay, pretty closely. Different law firms and different specialties, okay? Okay. If all of those fail, you can always look up and call the Kern County Bar Association. They'll give you a list of attorneys that do estate planning. Next slide. That is the 4-letter word of estate planning is probate. Okay? In most cases, and we'll get to it in the next slide, but in most cases, unless you have a very, very small estate, you want to try and stay away from going through probate if you can. Okay? Next slide, we'll talk about the actual reasons why. So, probate can be expensive. Each state varies as far as how that's going to be, but in the state of California, you're basically looking at about 2% of the overall estate is going to attorneys, and the court costs and the proceedings and everything else. Okay, 2% of the entire estate. So let's say that your regular assets, your checking, your savings, maybe your house, let's say all of that is worth maybe $500,000. Okay, but then you have a 401k, an IRA, other named accounts that have a beneficiary named to them. Those don't go through probate. That's a contract. However, let's say you have another $2 million in 401k assets. Probate's going to count the entire piece. So you're paying 2% on $2.5 million, not on the $500,000 that they're actually dealing with. Okay? So very important, if you have assets like that, you want to kind of protect from that. So attorney's fees definitely add up to that cost. Probate can take a long time. I actually have a very good friend who was in family law. She's actually a judge now, Superior Court in family law. A couple of years ago, she was actually the commissioner for the probate department, okay, in Kern County Superior Court. Talking to her about the process for probate, it was a minimum of 18 months. And that's for that was for an estate that had no contest. Nobody was fighting it. Nobody was contesting the will. It still took 18 months. So imagine if you're Aretha Franklin in Kern County right now. It can take a very, very long time, okay? And the last piece, if you are somebody who likes your privacy, as I like my privacy, you don't want to go through probate because that is all public knowledge, public record. You gave that brooch that your grandmother gave you and you pass it down as an heirloom to your daughter, guess what? Anybody who looks at that document is going to know who got what. Okay? So if you want to protect against that, we want to go a different route. Next slide. Estate taxes. We're going to go into this in a little bit of detail, but the crux of this argument is that most of us are not going to have to deal with estate taxes. Unless we have an estate that exceeds 13 million or more, we are not going to be in a position where we're going to have to really worry too much about estate taxes. However, if you are somebody who owns businesses or a lot of real estate and your net worth and your family's net worth is in the $30-40 million range, well, yeah, we're going to start having to really worry about what's going on here in estate tax land, right? So estate taxes are levied by the federal government. Some states, California is not too bad on estate taxes. And basically that's anything that we pass from your estate to your living beneficiaries, okay? There is what's known as a step up in basis. We will talk about that in more detail. I just want to kind of give everybody a heads up. We will be talking about step up and what that means and how it might affect your gifting strategies. A lot of people I hear that want to, start pre-giving assets to their beneficiaries now prior to them dying. Well, that could cause a tax hit currently by doing that. So you'd probably rather just hold off and let it go as a beneficiary to them after you pass rather than to pre-inherit them, okay? Next slide. Okay. Changes to the tax law for estate planning purposes and estate taxes. Back in 2012, the Taxpayer Relief Act basically made permanent some of the laws for 2010. And then we had the Tax Cuts and Jobs Act of 2017, which basically doubled the estate tax exclusion for individuals and families up to, if you're a married filing jointly, your exclusion for estate tax purposes is about $26 million. Okay, so like I said, if you're above $26 million, that's when we have to start worrying about estate taxes. Below hand, you have an exemption. So the only thing is, Tax Cuts and Jobs Act, that change in the estate tax law, that sunsets in 2025. Unless something changes with Congress, we will revert back to the 2010 rules and 2012 rules. And so we will wind up losing a good portion of that exemption. So we might, if Congress doesn't act, which, they call it an act of Congress for a reason, Takes a while to get stuff done. If they don't act, we will revert back to the 2012 rules, which basically cuts our exemption in half. So if your estate is more than 13 to 14 million, that's when we start having to worry about estate taxes. Next slide. Okay. So how do estate taxes work? Really quite simple. Basically, when you pass, the government or the probate department, however we notate that, basically assesses a value to all of your assets. Your home, rental properties, checking, savings, all of the accounts that you have, they're going to basically almost like figure out how much exactly that money is. They're going to tell you, hey, your estate is worth $750,000, whatever the total estate is worth, minus that estate tax exclusion. We just talked about it before. If you're married filing jointly, $26 million. So if you subtract $26 million from 750, well, guess what? You're less than zero. You have no taxable problem there, okay? However, if your estate is higher than that, you will have a tax rate. Current tax rule for estate taxes is 40%. 40% above that threshold. So if your estate is worth, say, $30 million, you're $4 million above the estate tax, right? So you're going to pay, on that $4 million above that threshold, you will pay 40%. Okay. Next slide. Again, this is 2023 rules, but for gift tax purposes and lifetime exclusions, this is one thing that is very much misunderstood. Gift taxes and estate taxes are basically one and the same. I get the question all the time, hey, I want to give my son $100,000 for a down payment on a house. How much taxes do I have to pay on that? The answer is zero. None. There's no taxes owed on that gift. What you have to do, you go ahead and give your son that $100,000. And if you want, I can be your son. Give me the $100,000. I'll take it. What happens is you file a form with the IRS. It's what's known as a gift tax form, notating that I gave my son $100,000. You subtract the annual $17,000, it's actually $18,000 this year. You subtract that from the $100,000 that you gave, and basically the IRS keeps that. There's no taxes owed, remember? They basically say, okay, that $72,000 or $82,000 that's above and beyond the exclusion for this year, we're going to subtract that $82,000 from your $12 million lifetime exemption. Does that make sense? So when you pass, all of those gift tax forms that you've given to the IRS over the last 50 years subtracts from that $13 million number. And if you've given away more than $13 million and that's been deducted, you now have no exemption for your estate. You will pay taxes on everything that your estate has in it. Okay? That's the piece of the gift tax that most people don't realize. Oh, I have to pay taxes now. No, you do not. It's tied up with the estate tax, and it just deducts from what that exemption is lifetime. Yes, sir.
One question that came in was, is there any tax cut limits? Has there been any changes since 2017?
Not when it comes to estate planning or estate taxes. There have been no changes as of yet. The only thing I would say is that in 2025, when this sunsets, we will wind up reverting back to the previous rules. And of course, those are always indexed for inflation, so it's not going to be necessarily exactly half, but it will be roughly half. Okay? Any more questions on the gift tax? Any more questions there? All right, next slide. This is the piece where I was kind of referring to. You have a $13 million exemption per person. If you are a married couple, it goes to $26 million. Okay. Flip side of that is, if your estate, let's say your estate is worth $40 million. You're above the gift tax or the exclusion, right, for estate planning purposes. but your spouse is still alive. Well, guess what? All of that passes to your spouse. There's no estate taxes on that currently. When your spouse passes away, that's when that estate tax takes effect. Okay? So you have an unlimited marital deduction. No worries about that. It's after the second spouse passes away, that's when the estate taxes take off. Okay? Any questions on that? Next. Okay. So this is the piece where I talked about where you want to really think long and hard and carefully about pre-inheriting your beneficiaries. I hear it all the time about somebody who says, hey, I want to put my son on our house. We own our house outright. He's going to get the house anyways. I'm just going to put him on the deed right now. You don't want to do that. And here's why. The difference between step-up basis and carryover basis. The big difference here, step-up basis. If I bought a house in 1970 and I paid $30,000 for that house, and that house is now worth $500,000, there's $470,000 worth of gain on the value of that house over the last 50 years, right? If I pass away and I have it named in my trust or in my will that my son gets my house, he gets the house at the value on the date of my passing, $500,000. If he sells it 6 months later and he sells it for, say, $550,000, the only taxes and the only capital gains he would pay would be on the $50,000 worth of gain from the step up in the basis. Okay? If, however, I had put my son on the deed as a joint tenant or a joint in common or something like that, and I pass away, guess what? His cost basis is $30,000. He wasn't even born yet, but his cost basis reverts back to the day I bought that house at $30,000. So now he sells it for $550,000. He now owes capital gains taxes on, guess what? $520,000 worth of gain. This is why you want to talk to a professional, because they will know you don't want to do that necessarily. And here's the reason why. Now, if there's not any appreciable gain, say you bought the house 2 years ago and it's gone down in value or whatever, then maybe there might be a situation where it might make sense. But for the most part, I try to stay away from that because the carryover basis becomes an issue. Okay. This goes as well for not just homes or real estate. This goes for stocks or other appreciable assets that you may have. Okay. Next slide. Next. Some basic distribution techniques here. So I'm going to go over on this side here. So the first, and we haven't even really gotten into wills and trust yet. We will get there in just a moment. What happens, and this actually, like we just talked about with Aretha Franklin, she died what's known as intestate, meaning there was no will, there was no trust, there was no estate plan to speak of. That's not a great plan. There is no plan. We'll talk about exactly why in a second. Second one is a more simple will. Okay, you can write one on the back of a napkin, and then that's what's known as a holographic will. There's a number of different ways to do it. But you want to make sure that it's signed, notarized. I would highly recommend talking to an attorney to set something like that up. And LegalZoom can be good for a lot of things. LegalZoom on a will might not be the best fit. Now, if it's a really simple estate, probably will work out fine. But if you have a couple more pieces of assets or things that you want to pass on a will, you probably want to talk to an attorney. Jointly held property. Most of us in here, if we own a home, we own it in joint property with our spouse, right? And the beneficiary designation. This is going that goes back to what we talked about before with contracts like 401ks, IRAs, annuities, things like that. You have a beneficiary designation. Okay, next slide. Here's the problem with dying intestate. Intestacy rules. your estate, the entire estate, is distributed to whoever the state determines, state of California. Now, it's not as crazy as just, hey, an attorney or a judge just says, oh, I'm just going to give everything to someone. There's case law as long as my arm as to how that is done. And there's a whole reason why you have probate attorneys that literally do this, and that's all they do, is because of these types of rules. So the problem is, let's say I don't have a will. I have a couple of minor children. Let's say I'm divorced. I don't have a spouse. Maybe my spouse has passed away. I have a couple of minor children. I'm estranged from my younger brother. I don't want him raising my kids. But if I die without a will or I die without an estate plan, under California state rules, guess what? My brother's raising my kids. That could happen. Okay? You want to make sure. Fees and taxes, probate, again, guardianship of minor children winds up being determined by the court, not by the will or the trust. Next slide.
Justin, we have a quick question from the audience, and it's,
Yes, sir.
do you guys set up wills or trusts, or would I need to talk to an attorney?
That's a great question. I can refer you to a great attorney. We don't actually set up the trust. That's a legal document. We cannot provide legal advice. I can provide financial advice all day long. But when it comes to wills or trusts, we do set up trust accounts after the trust has been done, and that's more of a financial vehicle, but we don't actually set up the trust itself. Okay? Great question, though. So, a will. This is a great starting point if you have a relatively small estate or a relatively easy estate, not a lot of moving parts. A will can be, just fine in most cases. So you get to control the distribution of the estate. I want $50,000 to go to my brother. I want $20,000 to go to my kids. However you want it done. Okay? You get to name a guardian for any minor children. God, don't let my brother raise my kids. I want my kids to go to so-and-so. Right? You get to name that. You get to elect someone to manage your estate. Who knows what that term is? Legal term. It's an executor. If you have a will and you name somebody to take care of your affairs after you pass, that person's term, that term for that person is an executor to your will, an executor to your estate. Okay? Next slide. Estate documents. Okay, there's a big difference between a power of attorney and a durable power of attorney. Okay? A power of attorney, a lot of people think that, hey, I have a power of attorney. I can do anything I need to do for so-and-so that I have power of. Okay? The problem is, in most cases, if it's not done right, that power of attorney document loses its force when the person you have power over loses either mental or loses capacity. Okay? Which isn't that the whole point of a power of attorney, is that you're going to take care of somebody if they wind up going through dementia or Alzheimer's or something to that effect? So a power of attorney sounds great, but it doesn't fully protect that individual, because once they lose, cognitive ability or whatever, you're not able to act. Okay? This is why a durable power of attorney does. Durable power of attorney allows for you to act on that person's behalf, even in a case where they are incapacitated. Okay? And that durable power of attorney allows for you to manage financial assets, maybe make some medical decisions. You can, those types of things that you talk about with that individual prior to taking on that durable power of attorney. Then there's a medical durable power of attorney, which literally only does one thing, that's medical. Okay, no financial, anything that you're able to do with that. And a living will. Okay. I would add to that a couple of other documents in your estate planning. One would be Now that it's not written, I'm having a hard time coming up with it. Not a DNR, but an advanced directive. That's what I was thinking of. An advanced directive. I'm a hiker. I like to go out into the backwoods and camp and hike. And sometimes I come back a little bit more beat up than I went in, right? I have a durable power of attorney. My wife can do those types of things. But in addition to that, I have that advanced directive. If certain things aren't working, let me go, right? And I want that to be maintained. Okay, next slide. Okay, this is the piece where we talk about jointly held property. Okay, there can be some pretty sizable tax consequences if we do things incorrectly. So we're going to talk a little bit here about joint tenancy. Almost everybody in here, if you have a spouse and you own a home, you own your house in joint tenancy with your spouse. Okay, meaning you are 50-50 absolute direct half owners of that property. You can have joint tenancy with 12 people, right? You can have joint tenancy with 12 people. The thing with that is everybody has to be an equal owner. There's no splitting of hairs. You're 20%, you're 30%, you're whatever. So in joint tenancy, it's literally equal pie slices for everybody. Anybody ever played the game at Thanksgiving where it's, you have a pie slice and you got the two kids and you have them. I tell one of my boys, you're going to be the one that cuts the slice and the other boy gets to pick which slice he gets to take. That way it's exactly down the middle, right? So tenancy by the entirety, it's a different way of doing joint tenancy. Pretty rare, honestly, in most cases. And then tenancy in common, a little bit more prevalent. But most cases, we're talking about joint tenancy, just a joint survivor kind of a situation. Next slide. So here's some of the dangers with joint tenancy. I may be in great financial health, but my joint owner might not be. And if that joint owner winds up filing for bankruptcy, guess who the creditors are going to come after? They're going to come after the property that I hold in joint ownership with that individual, correct? Whether it's hopefully it's not my spouse filing bankruptcy. I hope I would know that. But the change in property, this more in the case of instead of the joint tenant, but more of the joint in entirety or joint in common. What happens there is a change in the title of that property. If it's, again, going back to our previous situation, if it's a spouse, there's no issue. But if I own my home in joint tenancy with, say, one of my children, and I pass away, my half of that property is now added to my son or my child who owns that in joint tenancy with me. That could trigger a gift tax consequence. And if I am over the gift tax and estate tax limits, could create a situation where there would be a pretty sizable tax hit from the estate perspective. So you got to be careful when you're doing joint tenancy with people that are not your spouse, okay? Not to say that you can't do it, you just want to be a little bit careful about who you pick, okay? And the assets may be lost if joint tenants run into difficulty. Like I said before, if they file bankruptcy, they're coming after me and they're coming after that property, okay? And those potential tax benefits have to be shared equally with all individuals, okay? Just everybody has to be treated equal. That's why it's joint. Any questions on that? Mike, any questions from the? All right, nothing. All right, next slide, please. So community property laws is kind of a busy slide, but it's the United States of America. Anything that's in gray is a community property state. Guess what? We are in a community property state. What's mine is hers, and what's hers is hers, right? So not every state has the same laws as far as community property, but California does. What that basically means is, like I said, if we're in a spousal relationship, what's mine is hers, what's hers is mine. Community property, okay? Where that becomes a little bit different, let's say that I inherit from my parents, say $100,000 house or an apartment or a condo. Well, I can hold that because I'm the beneficiary of that, even though we're in a community property state, because I am the beneficiary, I can hold that asset as sole and separate property. Okay. I wouldn't do that, but if you did receive a sizable inheritance and you were going through some marital issues or something like that, you could conceivably hold that asset as sole and separate property. Okay. Next. So here's the contracts we talked about. Basically, life insurance, annuities, pensions, retirement accounts, those are named beneficiary accounts. You can name whoever you want. However, being that we are in a community property state, retirement accounts and pensions and such, guess who's your primary beneficiary by law? Your spouse. Okay. So you can change that, but it takes a little bit of legwork on your part. So in retirement accounts, 401ks, IRAs, those types of things, you can actually name somebody else as your primary beneficiary. However, your spouse, who is by law going to be the primary beneficiary, would have to sign an affidavit basically saying, I release myself from being the beneficiary of that account. Okay. I see that a lot when it comes to, say, second or third marriages, right? Where, hey, I'm sorry, I want my adult kids to be the beneficiary of my 401k. We're both coming into the marriage. You have your assets, I have my assets. My 401k, that's going to my kids. Just because we say I do, I don't want to change it to where you're the primary beneficiary. I want my kids to still remain my primaries. Then you would have to sign some kind of an affidavit basically signing off that. Okay. So it does happen. It's not as common as you think, but it does happen. All right, next slide. So here's the importance of this. Your beneficiaries are very, very important. I've been doing this long enough to see some really crazy things when it comes to beneficiaries. Right, TJ? All the time. We live it, we breathe it. Okay? So what happens if your primary beneficiary predeceases you and you haven't changed your documents? You need to have a secondary contingent beneficiary. Okay? And these Latin words, per stirpes or per capita, that's what's known as a standard beneficiary, or basically, do you want those assets to be given to your heirs' heirs if they predecease? So what that means, let's say I have a primary beneficiary and it's my wife. We have 3 kids. They are obviously my contingent beneficiaries. If both me and my wife were in an airplane crash or something like that, well, our assets would then go to our kids 1/3 each, right? That's the way we have it set up. However, and this is a horrible thing to think about, what if one of my children predeceases us and we didn't change that secondary contingent beneficiary? Okay, I have grandkids. If I have it as per capita, standard beneficiary, my son that had passed, his heirs would get nothing. His portion would be split then between the 2 remaining children. That's a standard beneficiary. If you want to go and make sure that everybody gets their piece, per stirpes is the way to go. That's basically his issue. So his portion, his 1/3, if he had 2 children, his 1/3 would be split between those 2 grandkids. That's what's known as a per stirpes. Okay? Does that make sense? Everybody kind of catch that? I know like sometimes can be a little bit confusing and complex, but the idea of, do you want your grandkids or whoever your beneficiaries, if they predecease you, do you want their kids to receive their portion? That's the way to go. Otherwise, keep it per capita. Next slide. All right, We're going to talk about trust now. This is what everybody came to see. They didn't come to see me talk about beneficiaries and stuff, right? Came to talk about trust. Next slide. Okay, what is a trust? Basically an arrangement where you're going to utilize this vehicle to pass your assets down to your beneficiaries and hopefully not have to go through probate. Next slide. So here it is in visual terms. You have a grantor who is the owner of the asset currently. They create a trust document through an attorney. They pass those assets that they currently own, and they take those assets and they put it into the trust. This is the part, this is the piece right here. Michael Jackson didn't do that part. It's great to have the document, but it doesn't do you any good if you don't put anything in the trust, in the name of the trust, okay? So you take these assets, you put them into the trust. You appoint a trustee. In 95% of the cases, that trustee is who? The person that's the grantor. You wear both hats while you're still living, right? Then when you pass, you name a successor trustee. I can no longer be the trustee. I'm no longer here, right? So what happens is you have the successor trustee. So we talked about before, if you die with a will, you have an executor. Under a trust, it's a little bit different. That executor's name changes to successor trustee, the legal term. You can still call it executor. They know what you mean, but it would be called legally a successor trustee. That successor trustee's job, their job is to literally take all of those assets and look at that document and do everything you said that you wanted to have done. Your beneficiaries get what they're supposed to get. We open up an estate account in your name, and we go through the process of paying your final bills, and off we go, okay? It doesn't go through probate in most cases. Next slide. So there's a couple of different types of trusts. Testamentary trust and a living trust. Next slide. We're going to talk a little bit about a testamentary trust. Basically, a testamentary trust is pretty much the same thing as a will. You still go through probate. Okay? So why pay the extra fee to have a testamentary trust if it's the same as a will? Okay? Does not avoid probate. It could potentially help alleviate some taxes and things like that, but for the most part, it's basically another word for a will. A living trust helps control distributions to your heirs. It helps manage those fees and taxes if necessary. And if it's properly structured, if it's structured in a way that this is where you need the attorney to do it, if it's structured properly in the state of California or wherever you reside, you would be able to avoid the probate. Okay? And your beneficiaries would get their funds a lot sooner. A lot sooner. Okay. Next slide. Okay, so we have a couple of different styles of living trust. We have a revocable trust or an irrevocable trust. Most people, when they're starting out, are going to have some kind of a revocable trust, meaning that you can make changes to that trust while you are still living. You can change certain things about it. You can add assets, you can take assets out. You buy a home and you want to put it in a trust. You sell the home, you take it out of the trust. Okay? That's what a revocable trust allows you to do. Helps with property management, helps with a lot of different things. Okay? And it helps to avoid that probate. However, once you pass away and your co-trustee, maybe your spouse, if you both pass, the trust now becomes irrevocable. Nothing can change. Nobody can add anything. Nobody can take anything out. The only thing that can happen is a successor trustee goes through the process of distributing the assets and closing down the trust. That's how a living trust works. While you're living, everything's revocable, right? And you can make changes necessary. As soon as the second individual passes, everything becomes irrevocable. Now, there's a second way to do it, and this is for folks that maybe in that high net worth individual. you can create an irrevocable trust. Okay. What that means is if you have appreciated assets, apartment buildings or whatever that have appreciated in value, and you don't want to pay the estate taxes on those things, you can build an irrevocable trust to basically shed those assets and get them out, and you actually wind up saving yourself on the assets for the appreciation. Okay. Pretty advanced stuff when you're talking about irrevocable trust. A lot of those wind up being, there's 1,000 different types, charitable remainder trusts or, those types of things. If you need help on anything like that, by all means, give me a call. We'll talk about it separately. Okay. Because the biggest piece is the potential estate tax savings, because you're able to get those assets into a different vehicle that is not you and it's not attached to you and it's irrevocable. Okay. You're basically gifting. Remember what we talked about, gifting? You're gifting that appreciated asset into a trust, letting it continue to appreciate, but you're not going to pay the difference on that growth, right? It stays in the trust. Okay. All right. Next slide. Have a couple of other little additional addendum trusts. This is what's known as a special needs trust. If you have a special needs individual or somebody in your family has special needs and you want to help them take care of themselves, a lot of times there's state and federal laws as to how much money that individual can make to be able to get the care that they need. By utilizing a special needs trust, you can basically shelter those assets, and those assets can be used to pay for that individual's care. Okay. Again, that's more of an advanced that, if you have somebody that's in that kind of a situation, by all means, call us. We can help you get in touch with an attorney that can help put something like that together. Incentive trusts. A lot of people think about it like a living trust or whatever. And it's like, well, you hear about the trust fund babies, right? Right? Trust fund babies. Well, yeah, my dad left me a trust. My granddad left me a trust. I'm not able to get that money until I'm 35 and I have to graduate college too. Well, that's an incentive trust. The grantor puts together this trust in the living trust, but then on their passing, it becomes an irrevocable trust. That trust is now administered by that successor trustee. And if you have incentives in there, which you can do, you can say, you gotta graduate from Yale. Well, I'm going to MIT. Well, you got to go to Yale to get that money, right? So that's a bit more of the you're parenting from beyond the grave a little bit, right? Maybe a little bit morbid, but that's kind of what it is, right? You're wanting your children or your beneficiaries to do certain things in order to get that money. That's an incentive trust. Next slide. Okay. Your estate plan should be updated periodically, at least looked at. I would say at least once a year. Why? Tax laws change. We already know that in 2025, the estate tax, if Congress does nothing, the estate tax laws change, right? So we don't want that to happen. So you got to pay attention to that. The composition of your holdings may change. You might buy another house. You might buy a rental. There might be 1,001 different things that you do. You might go through a divorce. You might need to change some things that way. Family situation can change, right? Always update it. I can bring TJ up here and talk about a couple of things, but definitely you want to update this regularly, because if you don't, we wind up trying to fix it after the fact. Next slide. Okay, so how do we put this knowledge to work? First off, thank you so much for joining us today. Really, really glad to have you here. First thing you could do, you can kind of go about it and do it yourself, right? Or you can do what 90% of people do, is procrastinate and put it off until later. And then they're Aretha Franklin, right? We don't want to do that. Or you can choose to work with us. We'd love to have you work with us if you're not already working with us. Okay, next slide. At MoneyWise, we take pride in not only helping our clients with their personal wealth, we help them with their taxes and guiding them and getting them in touch with the proper tax professionals, CPAs and otherwise, to help them with their financial life. And this last piece, the estate piece, if you're not able to do all of these things, we're here to do all of these things in one piece. Okay? That's your financial life. We want to make sure we're taking care of you. So if you want to, please give us a call. We have obviously lots of brochures and such. We have business cards at the front table. If you want to give us a call, we can sit down and do a consultation. Next slide. When it comes down to it, as the advisor, we like to be kind of that guy holding the umbrella over you when it's raining, right? Those storm clouds of bad taxes or bad investments or family situation or whatever laws, whatever. We want to be that buffer to kind of help guide you through life, okay? Hold that umbrella over you, leading you from your past to your future, okay? Again, thank you so much for joining us today. Debbie, thank you for everything you did to put this all together and get it all set up. Thank you to Mike George.
Absolutely. And if we want, can we open up to some questions?
Absolutely. Open it up to anybody that has any questions. I know it was a lot of information. I hit you with the fire hose a little bit, but
I want to mention a couple things that you talked about that we see all the time at Safe1. And a couple important things is, one is when he talks about funding the trust. Once you get that legal document from the attorney, it's important that you take your home, your property, your bank accounts, and you put those in the name of the trust. That's what funding the trust means. Because if it's outside of the trust, then it's subject to probate. So, for instance, my home is not in the name of my name and my wife; it's in the name of the trust, so that it follows that edict. The other thing that's important is you heard him mention a revocable trust. Revocable trusts are important because you can change it at any time. And one of the most common ones I see is that I have 3 children. One's estranged. He or she hasn't done what I liked. I'm not including him or her in the trust. But as time goes on, we reconcile, and now I want to have that 3rd child back in the trust. I just go to the attorney, and I have it redrawn, and those changes are made to where that third, in this instance, that 3rd child is then included. Once I pass, or my spouse and I pass, that's irrevocable. If that 3rd child wasn't included, that's not going to change. That 3rd child will not be included. So revocable, you can change at any time, but once the parties pass, it's irrevocable. It goes, and you want that. You want it to be irrevocable at that point, because no one's going to do something beyond what your wishes are.
Exactly.
So,
and I would add to that what Mike just said is, in my trust, I have a provision in there, and of course, I told you I have 3 sons, right? I have a 21-year-old, a 17-year-old, and a 7-year-old, so a little bit of a gap between the last 2. Well, each of them is getting basically a 1/3 of the assets, under the name of the trust. One of the provisions in the trust, because all siblings, sibling rivalry, right? They like to fight. If one of the siblings contests the trust as it's written, they don't get anything. I like to call it the get what you get and don't throw a fit clause. So if one of my sons, if Connor doesn't like what he got and he thinks he deserves as much as JT or more than JT for whatever reason, and he contests the trust, his portion is now split between JT and Brandon. Connor gets nothing. Actually, I shouldn't say he doesn't get, he gets $1.
We have one question.
Yes, sir.
Just from the audience. How do I put assets into a trust that is already established?
Great question. If you already have a trust that's been established, it's very simple. If you have a house that's maybe it's maybe in your name as far as joint tenants or joint, the husband and wife, basically it's a very simple process of going down to the county recorder's office and having that trust, having the house renamed into the name of the trust, taking that document down there. I think it's like $16 to get it transferred into the trust. Renaming a bank account. It's literally going down to your bank and saying, hey, I have this savings or checking account. It's in my name or my wife's name. I want to name this under the name of the trust.
Yeah.
Have your trust document there, and they will go through the process of renaming that
Yep.
account.
All you have to bring is the page, which is called the certificate of trust.
Bingo.
They're not going to get into the nitty gritty of your trust and who the assets are going to. Just bring the certificate of trust. It shows that it's established, and they'll move those accounts into the trust.
Correct.
Really?
Does it create any kind of issue if you wanted to refinance later?
No, typically no. You're not going to have any issues with that because, again, you are the owner of that trust, and you as the trustee have agency to do what you want with the assets in that trust. So they're still going to go off of your assets and your income when going through a refinance process. So it shouldn't cause any issues there.
No, because the trust is just another legal entity of
Correct.
which you are in charge.
Michael, we had a couple of questions up front here.
Suppose you do have a trust, and later on, like you mentioned, you buy or acquire a piece of property, but you inadvertently forget to put it into the trust. Does a pour-over will capture that?
In most trusts and in most wills, you will have what's known as a pour-over provision. Okay, so again, for that specific purpose, and if let's say you have a trust and it's already been funded, but you actually receive a piece of property and you forget to put that into the name of the trust, what happens? Well, in most cases, and this is where an attorney would help you with this, you would have a pour-over clause in that trust or in a will attached to the trust, basically stating anything that I own that I forgot to put in the trust actually belongs in the trust. Okay? I wouldn't want to rely on that necessarily. It's there for that purpose, but if you finally realize, oh geez, I forgot to put that in trust, just go do it, right? And then handle it that way. We have one more back here.
Can you repeat it for?
Yeah. So the question was, how easy is it to amend a trust if you had a situation like that? It's actually quite easy. You might have to pay a couple $100s to see that attorney to have them redraw or create that amendment for you. But that is if you have that revocable trust, basically creating amendments are relatively easy. It's about an hour of an attorney's time to go through that process, depending upon how crazy it is.
We have a question from the audience. It
Yes,
is,
sir.
do you add assets managed by MoneyWise into the trust?
That depends.
Yeah.
Here's a great piece. So never, ever, 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 did I say never? Ever put retirement assets into a trust. Okay, there's a very specific reason for this. One, they're already named as they have a beneficiary attached to them. Okay? A trust, you want to put your checking, savings, real property, those types of things in the trust. If you have a retirement account, qualified retirement account like a 401k, an IRA, those types of things, you do not want those renamed into the name of the trust unless there's a very specific reason. And that specific reason would be something to the effect of like a special needs trust or something like that. But under normal circumstances, if you were to pass away and you had named your 401k and you named your trust as a beneficiary of your 401k, okay, let's play this out real quick. Let's say you have $1 million in your 401k. We can all dream, right? We have $1 million in our 401k. And we die, but we have our beneficiary named as the trust. Well, the trust receives that entire $1 million up front as income. There were no taxes paid on that 401k while you were building that 401k, right? If you were to retire and take the money out slowly, you'd pay taxes on the money that you took out, not the entire $1 million, right? Well, under this scenario, the trust would receive the entirety of that $1 million portfolio all at once. And guess what the tax rate is on income coming into a trust? 40%. There's no tiers in tax rates on trusts. Okay? So again, talk to a financial professional because that $1 million 401k just became $600,000 really quick. Okay.
And real quick, just so the group knows, I get this question quite often. Should I put my regular checking account in the name of the trust? Sure.
Sure.
People think like is it going to be different the way I can operate? No, you operate the same as you do today, but it's in the name of your trust.
So what about the CDs? Because when we went in, we named our kids as beneficiaries. Do we put it into the trust or we leave it alone because we already named them at Safe1?
Okay, so you have
For
a certificate of deposit.
Yes.
Okay, so in a lot of cases now, banks are actually creating vehicles where you can actually name a beneficiary on normal, say a checking account. You can actually have a TOD, transfer on death checking account. That would be kind of the same as what we talked about before with like a transfer kind of a situation of a contract. So if you have your children named as beneficiaries on the CD, you might just go ahead and leave it as is, right? Unless, when those CDs mature, maybe the next one you do it under the name of the trust. It's possible to do that, but I wouldn't make any changes on it currently if you don't need to. Okay. Any other questions? Yes, ma'am. Again, going back to
repeat the question.
Yeah, so repeating the question. So the gift tax rules of the 18,000. If you're giving gifts to your children throughout the year and you're giving them checks, just give them checks, but make sure you don't go over the $18,000. If that's what you want to do, yes. But if you want to give more than that, there's nothing stopping you from giving your kids $30,000, $40,000, $100,000 a year. The only thing that becomes different is you have to file that form with the IRS above 18,000. So the exemption you have per year is 18,000. Again, going back to our previous scenario, if you wanted to give your son or daughter $100,000 for a down payment on a house and just gift it to them, they're not going to pay you back. That's perfectly fine. You can do that. Because you're a married couple, 18,000 from you, 18,000 from you. That's $36,000. Okay? So you take that $100,000, subtract out that $36,000 worth of the exemption that you have as a couple, right? And so the leftover, that $64,000 that's left over, you file a gift tax return for that. You don't pay any taxes. It subtracts that $64,000 from your lifetime exemption for estate tax purposes. So you can give your kids $1 million. Perfectly fine. Nothing stops you from doing it, but you potentially could harm your gift tax and estate tax exclusion at the end of your life. Yes.
Just in the 18,000 years ago, wasn't that 10,000?
They keep basing it on inflation. Last year it was 17,000.
Oh, yes. Okay. Okay.
Right.
Well, that's just going to keep going up then.
Yeah. This is the good thing about inflation, right? Yeah. Any other questions? Well, again, thank you to Safe1. Thank you to my MoneyWise crew for helping out and doing everything that they did. Have a wonderful day and evening. I'll stick around for any one-on-one questions if you'd like, but I'm sorry? And LaTroy. Oh, I didn't see LaTroy walk in. LaTroy is one of our other financial advisors at MoneyWise. Great guy. Smartest guy in the room. I can tell you that right now. All right. Thank you so much.